Please, Lordship. I would like to mention item number 13.
Item number
13.
Yes.
Lordship, connected matters are pending before this Honorable Supreme Court, Lordship. And the matter has not been listed. So I pray that this matter may come up after vacation.
Is correct? Good. Parties submit that the matter before the apex court is yet to be disposed of. Accordingly, this is matter. No, in view of the submission, just not according. In view of the submission, this is matter after vacation.
Similar prayer for item number 15.
15 also same.
Same, Lordship, but counsel is different. Mr. Devnath is there for the respondent.
Okay. Same order, just.
Lordship, I beg to mention item number 14.
14, yes.
Lordship, may this matter appear after vacation?
That is that foreigner.
In this case, I was directed to supply the Xerox copy of the material exhibit, Lordship. I have already supplied.
That is yet to be compared because it's not legible.
Is it? You can compare it with the court's copy. There is material exhibit is before the court. Okay, on the request of the petitioner, place this matter after vacation.
No, Lordship.
Highly obliged.
Lordship, I beg to mention item number 3, Your Lordship.
Item number 3.
Yes, Your Lordship.
Kanti.
Yes.
No objection, my lord.
2015 matter, why are you keeping it pending? Is there any interim order, anything?
Yes, Lordship.
Interim order is there in this matter?
Yes.
What is the interim order? We'll vacate this interim order. If you ask for time.
What interim order?
Status quo is there, I guess.
Status quo.
Any interim
There is a status quo order. A private third-party interest has been created in
is
favor of
inconsequential. Status quo order was passed when?
when the motion was moved. No, not that. When the just check it. Sorry. Injunction.
Yes, please wait. Wait, please, wait. Hold on. We are in the midst of something else.
2019, Your Lordship.
When wouldn't the court pass an order?
We'll vacate this interim order, Mr.
Lordship, last chance may be granted, Your Lordship. Last chance may be granted, Your Lordship.
Oh, this is enough. You see, if you see the order sheet, this matter has been adjourned only at your instance.
Yeah.
For so many
Will be
times.
passed in this case. Yes, 254. Lordship, in this case 254.
Lordship,
254 2015. Status quo order was passed, Lordship. The first order of this case 254.
Whether petitioner is in possession.
The private respondent is in possession.
The private respondent is in possession. The status quo is in their favor.
Basically that, but they can't utilize the
There is
land.
no need to intervene.
The Lordship, but they can't utilize the land. They can't do anything. No permission is granted. You can't utilize the land.
Yes, I can.
That is only still the renewable deed.
Lordship, but then
It is not there. This order was passed on 17/12 when it granted status quo till the returnable date only. That was 31/1/2016. Thereafter, there is no status quo order.
then there is no bar for that.
There is no bar. If there is no status quo, there is where is bar. There is no bar. You check the order sheet properly.
Yeah, please.
See. Okay, you will get. Just say, Mr. So-and-so, appearing for the petitioner, seeks grant of some more time on the ground of non-availability of the learned senior counsel appearing in the matter.
Lordship, similar prayer for item 7, Your Lordship.
The counsel appearing for the respondents objected to the prayer granted, prayer made by the petitioner. However, for the interest of justice, matter is adjourned. List after vacation. Come after vacation.
Lordship, similar prayer for item 7, Your Lordship.
Item?
Item 7, Your Lordship.
7.
Who is the other side here?
This matter I'm appearing along with the Advocate General.
Any private respondent
indeed,
here?
Lord.
Any private respondent here?
Private respondent is the one.
Who is appearing for private respondent?
Mr. Hazarika
He's not here.
is not here. In this case, we were directed to place the latest position of the recruitment of government LP school teachers. We have received that, Lordship.
This is a case with regard to that
Appointment of the teacher. They are
that
leaving,
disabled,
Lordship.
the person with physical
Yes,
disability.
yes, physical disability.
Okay. On the request of the learned counsel for the petitioner. This is matter after vacation.
Obliged.
My lord, I have a small prayer, my lord. Item number 6, my lord. We have sought for this award statement from the Deputy Commissioner pertaining to this LA case proceeding. Some length of hearing was done, but then court wanted to see the statement of award statement of that LA. We are yet to receive it from the Deputy Commissioner Isgaru Hills. So I am praying for if the matter can come up after vacation. In the meantime, we'll pursue.
Litigation matters become there. You see, like many matters parted, and now it has become very confusing for the court.
Yes.
Because neither the writ petitioner could enclose, so at least the state respondent should produce it. That is what the observation came. So we are trying to follow it up to get the copy of the award statement, my lord.
My learned friend has successfully prolonged the litigation. So
Not,
after vacation.
it is the writ petitioner who is supposed to stand on their own, and they are trying to stand on the documents filed by us.
A gentleman's order will speak volumes.
No, my lord, that is absolutely an incorrect statement.
What is to be done?
After vacation, my lord, in the meantime, we'll try to obtain the statement, award statement.
Mr. S. Sangupta, additional GA appearing for the additional senior GA appearing for the
State respondent.
respondents. Praise for grant of further time for production of
Award statement.
award statement. Mr. Sangration, Honored Citizen Council appearing for the petitioner.
Let us hope that he will produce after vacation.
What we say? Reluctantly agreed.
Yes.
Has no objection. Okay. Accordingly, this is matter after vacation.
Highly obliged, my lord.
My lord, I beg to mention hearing number 4, Majendra case, my lord. It has a connection with the pending writ petition in the writ petition bench. So, may I plead for after vacation,
This is also land acquisition matter.
land acquisition matter regarding ROW.
There is a connected matter pending before.
Land acquisition bench.
Okay. Correct. Is it correct?
I've informed the GA also here.
It is correct. Pertaining to
Asking him not to be replied. The court was putting question to him. Did not expect reply from you. Okay. Just say on the joint request of the parties This is matter after vacation.
Hello.
Wait, please, Your Lordship. Lordship, I beg to make a mention of item 11.
Yes.
Lordship, I'm praying this matter may be listed after vacations.
Okay, on the request made on behalf of the petitioner, list this matter after vacation.
Obliged, Lordship. Lordship, a similar prayer for item 12.
Item
12, Lordship. 12. Yes.
What is that item 12? Who is appearing item 12? You have objection? Item 12 also? Anything? Any problem? Item 12 also? You have written for these things. Item 11. Item 11 already? Yes. So item 12 was the same order, just only change the name of the council for the respondents.
Highly obliged, Lordship.
Yes.
May I please, Your Lordship? Your Lordship, I beg to mention item number 5, Your Lordship.
You are appearing for?
Petitioner, Your Lordship.
That is the Nokma matter.
Lordship, in the last order, they were asked to correct some
Yes,
impugn
Your-
order, some date, maybe.
Type copy, Your Lordship, since there is
There are a lot of,
so many
date
technical
mistakes.
error. So we require some more time, Your Lordship, to prepare.
You go after vacation. Then.
Let him correct, Lordship.
After a vacation.
Lordship.
Okay, on the request made with the petitioner and not objected to by the counsel for the respondent, list this matter after the vacation. Okay.
Obliged, Your Lordship.
First place, Lordship.
Please, Your Lordship, I beg to mention item number 17.
Item number 17, anything left? Nothing.
The Learned Council is on sanction leave, Your Lordship. I pray that this matter will come after vacation, Your Lordship.
Okay, it's the last item. This is a new matter.
Yeah, it's no objection.
Item 17 on the request of the Learned Council of petitioner, list of vacation.
Obliged.
Please, Lordship. Lordship, I beg to mention item number 8, 9, and 10. They are connected matters, Your Lordship.
8, 9 and 10. CBI.
Your Lordship,
Yes.
I pray that the matter may be listed after vacation.
Same on the request of the Learned Council petitioner, list after vacation 8, 9 and 10.
Obliged, Lordship.
Yes, yes. Wow.
Supplementary cause list, item number 1. Please, Your Lordship.
Yes.
This is an order which I challenge my lord, wherein my application praying for recalling of certain prosecution witnesses was rejected. My lord, so far as
Application under 311.
yes,
Yes.
the impugned judgment is at page 73. But if I may say, before that, my lord, if I may say that I was arrested in June 2014 and I was in custody, and in about April 2020, I was released on bail. Now, while I was in custody, my lord, the prosecution, the trial proceeded, my lord. The prosecution examined 20 witnesses, my lord, and thereafter, my lord, 22 witnesses, my lord, and after examining 22 witnesses also, everything was happened while I was in custody, and thereafter they filed an application under section 311, and which was allowed, and the prosecution witnesses were 24, my lord. What I am trying to say, pointing out this, my lord, that the accused, my lord,
This order is passed, which one, which date?
page 73 in June.
Which date? What is the date of the order?
The date of the order is in June, my lord, 26, 2023.
It's quite some time back, isn't it? Like, this is.
And the last page,
Order
my lord,
is
page 92, we have the date.
June. What is the status of the case?
My lord,
What is the current status of the case?
it continues, my lord. Last time when it was posted, my lord, I mentioned that I had approached this honorable court, my lord, but because there was some error in the certified copy, therefore the matter could not be heard on merits, and
It is not barred by limitation.
no, my lord, it's not barred by limit. My lord, we had moved this matter, but it was not numbered along with an application for waiving of certified copy. But by the time it was posted, my lord, I had got the certified copy, but there was an error. So this honorable court disposed of my petition because it did not require, and I had returned the certified copy to the office of the session judge for correction. And it was returned to me, but even then all corrections were not done. Be that as it may, I filed the certified copy which I got it the second time. And the office, I had filed it along with other documents also by way of additional affidavit, but the registry of this honorable court did not accept the affidavit, saying that unless there is an order from this honorable court, they cannot accept the...
Whether this original certified copy is needed for preparing and revision?
For revision, yes.
It is needed?
Yes. My lord, for calculating the time.
I thought it is only for appeal, not for...
Even
for revision also?
Revision also, my lord. Just for the purpose of actually it's calculating the time, because original copy has gives a authentic it was filed, my lord, in time only, but only because the certified copy was not there, my main revision was not numbered. And my affidavit here also is not accepted. I had filed some other documents also. Anyway, my lord, to cut it short, my lord, what I was saying, that even my prosecution witness was not there, my lord. I came before this honorable, that application was allowed, and I had, along with that, I had filed this application saying that I had filed 3 applications together. One for recalling prosecution witnesses for cross-examination. Second, I filed an application saying that I did not get the relevant documents and which should be given to me under 207. And I had filed third application, my lord, for recalling of witnesses. My application requesting for service of documents was not allowed to be filed. My application for...
Allowed to be filed? Means?
Not allowed to be filed. Means not allowed to be filed. I was not even allowed to tender it also. Said that unless there is an order from the court, it will not be filed. When before the honorable session judge, I pointed out, they said you don't need to file the application. I said, okay, let me have the copy, because he's in custody and he does not even have the copy. I do not even know.
When did you file this application?
My lord, that was in 2019. 2021.
This trial started from when?
Trial started, my lord, long time back, my lord.
And you were not represented by a lawyer?
I was represented by a lawyer, it appears. From records, it appears I was represented by a lawyer.
You did not engage a lawyer?
My lord, I was in custody and I did not have anyone to help me. I was in such a condition.
You were provided with legal aid?
Everything happened, my lord. There were lawyers, my lord. Everything happened.
Tell us directly. Just say who
the lawyer was there. Lawyer was there, legal aid was there, thereafter some private lawyer was also there, but
you
somehow...
private lawyer also?
Yes, but somehow, my lord, this, even this 207 documents which was to be supplied, all of them were not supplied. So when there was change of lawyers, the lawyer thereafter pointed out that even the relevant documents are not given, and formal application was filed asking for the list of the documents which are not available. But even that application was not allowed. I am not on that just now, because thereafter I spent money and took not certified copies, I took copies, my lord, from the prosecution. What I am trying to point out is, my lord, the condition in which the trial proceeded against me, this is what I am trying to project. And my applications was rejected, my lord. I came up before this honorable court for allowing prosecution witness. There was no evidence from my side. and my application was rejected. I came up before this honorable court. This honorable court allowed the revision petition, saying that, okay, don't ask for time, within this date you present your witness. I presented my witness, my lord, without asking for any time. It was the defense witness was cross-examined on the same date and was discharged. So far as by the time the second witness was to be produced, my lord, there was COVID, my lord, and in the meantime, before the COVID, my lord, the second prosecution witness suffered a paralytic stroke, my lord. We filed an application seeking for commission. That application was allowed. But before the commission really happened, there was COVID, my lord. And after the COVID, my lord, when by that time, my lord, the prosecution witness recovered also, was able to walk with a little bit of assistance, and was the
prosecution witness or defense witness?
Sorry, I'm extremely sorry, my lord. The defense witness, my lord, was recovered to quite an extent, that was able to walk with some support and was able to speak slowly, my lord. And therefore, since by the time, because of the elapse, I said that, okay, this is the situation of the defense witness, the court allowed to bring the defense witness for examination. The second defense witness, my lord, filed the evidence on affidavit, and while cross-examining, my lord, the prosecution was not finding very comfortable to cross-examine, and therefore, on the prayer of the prosecution, my lord, the honorable court asked me to discard that witness and to present some other witness. And I had no choice. The person who was assisting that witness, my lord, physically, was again substituted by as a defense witness, and she was examined on the date given without any asking for time, and cross-examined and discharged, and my defense witness is closed. I have no grievance so far as that, but I'm just relating this story to say, project, my lord, the kind of situation I was faced with. Now, my lord, I ask for recalling of 4 witnesses, my lord, for re-cross-examination, which may be permitted. And so far as the delay part is concerned, my lord, I also prayed before this honorable court that let my application be allowed. It's a genuine reason why I'm asking for.
See, the trial court has given reasons.
Yes, all the reasons are not correct. All the reasons are not correct. Yeah, that is why I'm before this court.
So what is for interference in revisional jurisdiction? Scope is very limited. Just tell us what is wrong with it.
So far as 311 is concerned, or even the Honorable Supreme Court and even this court has laid out a number of times, my lord, 311, unless it will cause prejudice to the other side, my lord. Ultimately,
who will decide what will cause prejudice or not?
The court will decide.
Then it
the court will decide.
This is your conduct also, is it?
My conduct, my lord. My conduct, looking through my lens, my lord.
Specifically saying there is a suppression on your part. Many things.
I'll come to that. That suppression part, my lord, I will come to that. That is why I wanted that additional affidavit to be filed, which the High Court registry did not allow me to file, saying that unless there is
a question of substituting those views, you see.
It's not question of, my lord, the views.
Examine the records, materials by itself.
The views.
Come to this finding, and if this finding remains.
My lord, the court did not have the records. That is why court said that I suppressed. Because that application was moved before that court, that application record was before the court.
We will believe the order. There is no reason for not believing.
The records, my lord, that means the records was not there before the trial court.
Which trial?
The record before the trial court, the court which delivered the impugned judgment did not have the records. Otherwise, how can the court say that I suppress when the material is before the court?
It seems like there are many things.
My lord, it only seems, my lord. It only seems, my lord. I will show, my lord. It only seems, no doubt.
No, this court has referred to the relevant part of the order.
Let me place the order, my lord. I will say which are incorrect. I will say even factual parts are incorrect. And my lord, saying suppression, when I moved that application before that same court, it has been rejected. and the subsequent application is not recalling of the same witnesses, how can it be? How can the court say that I am suppressing facts when the records are before the honorable court?
But then it is your duty to disclose it.
Yeah, I did it. That is how the court knows it.
Does it mean that 311 is there? You will file applications in piecemeal. Today you will find one application calling 3 witnesses, then another after subsequent stage, and call another these things, depending upon what development takes place. Even after 313, you ask for calling for these things. Now your each and every stand taken in 313 needs to be supported by evidence. Then you will go on filing application at any stage. Is it the law? Does it 311? Whether 311 says it?
My lord, while laying down the law, my lord will also kindly appreciate the situation I was in. I was in custody. It was honorable court's duty also.
See, that is
when
why
I am in custody, ultimately, what is the trial court doing? The trial court is trying to find out the truth.
See,
That is what.
If that is the thing, then criminal court will never come to an end. Criminal trial will never come to an end.
Let the people behind it. In that case, my lord, I don't have any. My lord,
See,
my lord.
There is a procedure to be followed.
My lord.
It doesn't mean that whenever you make a prayer, okay.
My lord, that is what the prosecution.
311, you see, like you cannot go and ask, you see, appearance of witness as a matter of right. That is not there. There is a discretion to be exercised by the court.
Exactly, that discretion will be exercised only for the prosecution's favor, also in favor of the defense witness. In my respectful submission, while answering my own question, my lord, the honorable court has to give more opportunities to the defense, because the defense, what does the defense say? The defense,
so many times
even the documents has not been supplied to me. My 207 application was
We are
not
not
there.
on document, not on the question of document. Do not
My
come to
lord,
that.
I have stated that in my petition.
That is okay, but then here right
My
now,
lord, it is not okay, my lord.
see, your challenge is only with regard to this.
I will show this. I will show this, my lord. If this trial proceeds as it is, what can happen? Either I will be acquitted, or either I will be acquitted, or I will be given a life sentence, or I may be hanged to death. My lord, if these are the only situations that can happen at this stage. If I am acquitted.
These are the only situations, yes.
Exactly, these are the only situations. Now, shall I be acquitted without even giving me the complete documents and giving me a liberty to cross-examine the prosecution?
Are you anything on documents here?
My lord?
In this petition, your challenge is only with regard to the order dated 26, isn't it?
Yes, my lord.
Then it speaks only with regard to calling of witness, nothing else.
Okay, in that case, my lord, even the learned trial court went behind, my lord. When behind the application said suppression of facts, my lord, that is what I am saying. This is what is happening. This is what was happening even with the accused at the trial court, my lord. And even, my lord, when I presented the defense witness, why I was compelled to discard my defense witness. Everything was going in favor. Even then, my
What is the stage of the case now?
It is my witness evidence was closed, my lord, and thereafter I have come here, and on the last date when the matter was fixed, my lord. What is
the last order of the court? Yes,
last order was just about 2 days, but 2 days or 3 days back, my lord, wherein I pointed out to this to the learned trial court that this matter is pending and is likely to be listed, and the matter was adjourned.
There is no matter pending here. Was there any matter pending here?
Yes, my lord. By that time it was numbered, my lord. Just 2 days or 3 days back.
Passed by.
Yeah, I told the court. I did not suppress, my lord. I told the court that there is no stay order, and there is no stay order because of that error in the certified copy.
Yes, state. What do you say?
Well, let me place, my lord.
My lord, in my respectful submission.
This is only a question of law to be decided.
Yes, question of law. I will let me place the question of law also.
Yes, you can.
Let me place the question of law. Now, may I complete, my lord?
Just initially, if they do not object, then you get.
Yes.
Lord, in my respectful submission, my lord, the order of the Honorable Sessions Court is very detailed, my lord. There is no information.
You have any instructions in this matter? Any further instruction in this matter about the current status of the case and all?
Current status, I do not have the instruction.
Yes, okay. Please. Okay, madam, please. It seems they have objection. Yes. You just give us what point? What?
Yes. My lord, I place the order because this honorable court has by the time gone through the order and also formed an opinion that I suppressed made facts from the court. So let me
court?
place
You are talking about which
page
court?
74.
You are talking about which court?
My lord, the trial court formed an opinion that I suppressed,
Yes.
and this honorable court has gone through that part of the judgment also. So let me place it, my lord, at page 74.
Page 74 of your fear.
And my lord, even when the learned trial court said this, my lord, because I had conducted that hearing of that application, I told the court that I am informing this honorable court that I filed an application earlier which was rejected. But the honorable court said that you did not mention it in the petition. I said because I did not mention
What
it.
happens in the courtroom?
My lord,
How this court will judge?
my lord, when it is a statement at the bar, this honorable court will definitely give a value to that, my lord. I expect that much, my lord. Page 74, my lord. The accused Kain Lamare filed an application under section 311 on 12/9/2022, and the application that is 60 of 2020, praying for recalling PW1, PW2, PW3 and PW5, these 4 witnesses for cross-examination. The prosecution filed show cause objection of the application mentioned above. This application was heard on 7 March. During course of hearing, certain facts were brought to the notice of this honorable court, my lord. These are the facts which was not disclosed in the application. So what I said, I didn't really took note of this, that it was recorded. It is recorded also. I brought it to the notice of the court, and therefore suppression has been used loosely, if I may say so. Which was not disclosed in the application for recalling the witnesses filed by the accused. Learned counsel for petitioner claimed leave of this honorable court to bring those facts by way of an affidavit. This court right and allowed, and therefore I filed an affidavit, my lord. I am skipping these facts, and I filed an affidavit on 13 March. Contention 6.1. Learned counsel for petitioner argued that accused was examined under section 313 on being confronted with the prosecution evidence. He has stated that he never visited the house of PW1 and he was never presented at the place of occurrence. The accused could not properly cross-examine PW1 in absence of proper guidance. It is only after engaging a new lawyer the accused learned that he was not provided proper defense. The accused has not taken defense of alibi under section 313 CRPC. 313. The accused has taken defense of alibi under section 313. However, none of the prosecution witnesses were cross-examined on this point. Even this honorable court itself says, my lord, that no one were examined on this point. Even the statement of the accused under section 164 was not properly recorded. It is also argued that
what is the plea of alibi? The fact of not being present in the place of occurrence.
Yes.
Or fact of being present in some other place at the time of occurrence.
Not being present in the place of occurrence, and so far as the defense witnesses, there are two aspects. Yes.
One is that you say that I was not present at the place of occurrence.
Yes.
And the other is that you say that at the time when occurrence took place, I was in some other place.
That is in.
Now, what is your plea in 313?
In 313. In 313, it is that I have never gone to the house of PW1. So and in the defense witness...
You did not say that you were in some other place. So can it be a plea of alibi? That you say that I deny that you are not there in 313? Can it be strictly a plea of alibi?
My lord, even the defense evidence that has come was that I was in some other place and specific.
That is different. We are asking a question about alibi. What can be treated as plea of alibi? Accused denying his presence, saying that he was not present at the place of occurrence. Can it be regarded as a plea of alibi?
My lord, that whether 3113 was led that way, I do not know. It's a magistrate who leads 313.
But in the contents of the statement, you know.
My lord will understand that there were not lawyers in front even giving 313 statement. They were village people, my lord. So whatever.
No. To treat as a plea, what should be treated as plea of alibi? That is the work of the lawyer or the court. It is not the work of the accused to say.
In 313, my lord.
The
Sorry.
asking the question which this court is asking.
Yes, this I understand,
what
both.
will be treated as a plea of alibi?
Both, my lord, that you are not present and that you are present
Both.
elsewhere.
So if accused denies in 3-1 examination that he was present in the place of occurrence, that also will become place of alibi, plea of alibi.
That
You want to say?
I was present in the place of occurrence.
No. You say I was not present. So
My
moment
lord-
you say I was not present, that will become a plea of alibi.
Yes, my lord, it will, how strong it will be, it will depend.
No, that will be plea of alibi you want to say. Okay,
Not-
go ahead.
If I am not, I was not present, may not be a plea that way, but here the language is, he did not say I was not present. He said, I have never gone to the house of PW1. And
So that becomes, if he says I have never gone to the house of the victim, or sorry, okay,
yes.
then that will become a plea of alibi.
Yes, my lord, it will be a plea of alibi. And when I put the question, because here I am answering,
Yes.
here the question to which the accused answers is, I'll read the question, my lord. Actually, that affidavit, we did not file it, no? That affidavit was not accepted by the registry, else I actually had it ready. Can I place a
Affidavit for what?
placing this 313 on
Is it
record?
required? I don't think it
I
is.
thought just for convenience.
See,
Just for
you are
convenience.
a senior counsel. The court will ask you a question
Yes, okay, I'll
in
answer.
order to get itself enlightened with the thing.
Okay, I'm grateful.
Many things the court will definitely get from you.
My lord, so far as
That is why
the
these specific questions are coming.
I get it, my lord. So far as the question to which the accused answers is, the question is put like this: PW1, namely so and so, PW2 stated in the evidence that Yus Kain Lamare, along with so and so, so and so, so and so, and so and so since deceased, came to her house armed with guns and sharp weapons. What do you have to say? It is not true. I have never gone to the house of PW1, and the occurrence that whatever happened, my lord, it was there only. So and that was a specific
That is what
question
you want to say, that becomes a plea
it
of
was a
alibi.
plea of alibi. And to the last question. Do you have anything further to say? Yes, I went to Clariat police station on being summoned by the police. On reaching police station, I was arrested by the police, threatened and beaten up, saying if I do not admit to the crime, they will shoot me. I have falsely been implicated in the case.
Okay, it has nothing to do with plea of alibi. That statement has nothing to do with plea of alibi.
This statement is part of, yes, I understand. This statement is part of 313, and this is the situation that he was in, which he has stated in 313. This I am pointing out. It's nothing to do with plea of alibi.
Yes.
And in the defense witness that I have been allowed to be examined, that too after I approached this honorable court, the defense witness has given a clear evidence, and in cross examination also has not been damaged, my lord, that the place wherein
It's
the
okay.
accused was
No need to
present.
go to merit. You see, this will have no, what bearing it will have in this thing. You just point out to the order and just say which part is not correct.
And yes, it is also argued that there are serious 6.2 that there are serious inconsistencies in the prosecution evidence, raising doubt on veracity and integrity of the witness. The learned counsel sum up the argument by submitting that the truth has not been laid before the court, and for the just decision, the accused may be permitted to recall PW 1, 2, 3, and 5 for cross-examination. The learned counsel for the petitioner accused, in order to fortify her argument, has placed reliance on UT of Dada and Haveli and Varshaga. These two judgments I rely upon even now. Objection. The learned prosecutor in response submits that the instant application has been filed by the accused solely with an intention to delay the proceeding. The petitioner accused has appointed counsel of his own
Anything
choice.
wrong with the submission?
Yes.
Objection?
Yes. Because once I was allowed, without seeking any adjournment, I produced my prosecution witness, was examined, was discharged on the same day. The second witness suffered a paralytic attack and was unable to move. I filed an application for commission with complete address to say that she is in this place and if commission can be granted so that there is no delay in the proceeding. But
anyway, proceed. It's all right. It's all right. It's all right.
So that is how it is incorrect. I did not.
It's okay. It is a submission.
Yes.
When you come to the finding of the court, you point out.
Yes.
Things. See, incorrect submission order, they have a right to raise this.
Yes.
Whether it is correct or not, that we'll see later.
Further, the defense of alibi taken by accused under section 313 has to establish by leading defense witness. The defense of alibi cannot form the ground for recalling the prosecution witness. The prosecution further submits that the witness who recorded the statement of the accused under section 164 was examined as PW20. No prayer is made for re-examination of PW20. I made a prayer earlier, it was rejected. As far as the contention of the accused that the statement of the accused under section 164 CRPC was not recorded properly is baseless and it is only an afterthought. The prosecutor submits that the prayer of the petitioner for recalling the witness is in disguise of retrial. Plea of alibi under section 313 CRPC cannot form a reasonable ground for recalling the witness. The prosecutor also submitted that similar prayer was made earlier on the same ground and it was rejected. The said order was never challenged. The prosecution vehemently objected the prayer of the petitioner accused on the above argument. Facts of the case. Before this court examines the contention of the rival parties, the facts of the case, which is essential for the disposal of the instant application, is briefly summarized. Charge against the accused Kyle Amare was framed on 27/8/2015 under section 30234. The accused pleaded not guilty and demanded trial. The prosecution during the course of trial examined 24 prosecution witnesses and thereafter the accused Kyle Amare, but the court did not take about their application for recalling witnesses, 311 application. That is not mentioned anywhere here. Although that was
311.
The prosecution also filed. Theirs was allowed. And it was added to the, and the witnesses were added to the army of witnesses they had.
Did you challenge it? That when the prosecution...
My lord, I was in custody. I did not even know what I need to challenge. That is
defended by a lawyer, you see.
My lord, yes. A lawyer was there.
And just proceed.
A lawyer was there who did not even, like, whoever was there, I don't want to say anything, my lord. The 207 petition, till the filing of that application, the 207 papers were also not given to the accused. Now, if my lord asks the question whether the lawyer is there, I say under quotes, a lawyer was there.
We will not go into all those things.
But this fact is
not
there.
our duty to judge all those things.
My lord.
We just see whether opportunity was available to you or not. That
207 is also an opportunity.
If it is there,
207 is also an opportunity. That I was not given. 207 is also an opportunity.
We are not on 207. Harping on it again and again. No.
I have stated in my petition though.
That is all right. It is all right. We are not right now. We are not dealing with that.
My lord, after my hanging, no court need to go into whether it was allowed or not allowed. I take it that I will be convicted and I will be giving life or I will be giving a death sentence. My lord, taking that into situation, what will be the implication? If I am allowed, what will happen? 2 days?
Please proceed. See, like
from June, we are in November, December now.
Ifs and buts, presumption and all those things.
My lord, it's not presumption. It's a necessary corollary.
What happens in trial and all? We do not know. That we'll just see what happens after the judgment is delivered. Let us just be confident.
Only 3 things can happen, my lord.
See?
No fourth possibility I see.
This is the 313. Just proceed. The
prosecution during course of trial examined 24 prosecution witness and thereafter the accused Kyle Amare was examined under section 313 on 29th August 2016.
2016?
Yes.
And now you are seeking this thing.
My lord.
Recalling of some witness on the basis of your 313 examination 2016.
Yes.
7 years.
Yes. My lord, even if I may point out, my lord, if it is seen from one lens,
Yes.
then everything is against me. If it is seen from the lenses of the accused as well as the prosecution, then the real story can be seen. Even the charge sheet was not submitted. Charge sheet was beyond time, my lord, but I was not granted bail and I was continued in custody.
See all those points, which way it will help you in
My
this, so far
lord,
as this application is concerned.
this is a continuation of the trial. The trial has not culminated, and therefore, my lord, I am raising the point when the trial has not culminated. Where else will I raise this, my lord? I raised it before the learned trial court. And it still continues, my lord. 207 documents still have not been served upon me.
Yes, please go on. Go ahead. Go ahead.
And if such is the prosecution demeanor, my lord, why hearing also required? Let there be no delay. Let it be argued and let the hanging or the acquittal, whatever happen, let it happen. Why this drama also?
Why you are going that far? See,
my lord.
just because you have
my
liberty
lord,
to say whatever you say.
I have said it in the petition, my lord. I have said it in the petition.
No. See, whatever you state in the petition doesn't become correct. You see, we are
That
deciding.
is why records are necessary.
Please be mindful of the fact that we are here on 311. Please be confined to these things. Do not go here and there. That will not help your case. Please.
I was just trying to present the holistic picture, my lord.
No. Just
because this is the last resort, my lord. He does not have.
It's all right, madam.
This is the last resort, my lord. And since I could not persuade there, I am trying the last resort.
Just come to the impugn order and just.
The accused entered defense and examined 2 defense witnesses on 6th February and 4th August 2020. It is apposite to mention here that there are 8 accused persons in the instant case. The other accused persons had also entered defense and produced defense witnesses. That on scrutiny of the record, it is discerned, the records were scrutinized only for the favor of the prosecution. It was not scrutinized in favor of the accused. It is discerned that it will not be necessary.
Can those kind of submission be entertained in 397 application?
My lord, I question myself. Should it not be? Even when should it not be, my lord, I put a question to myself. There should be a holistic view, my lord. Where will the accused go?
You are a seasoned lawyer. You know what is to be submitted. What is things.
Well, that is
confined to the scope of 397.
I will do it by the sometimes my law is beyond the square bracket also.
These things.
CRPC does not apply in Meghalaya. CPC does not apply in Meghalaya, my lord. Therefore, sometimes.
Now everything applies.
Now it applies.
And the spirit of CRPC is
exactly, the spirit applies. Sometimes we need to.
What is the difference of spirit and letters?
My lord, the spirit is that you do not bind yourself with the technicalities that is laid down.
But then, which way the interest of justice is served? Without following any procedure?
Does it mean
that no procedure should be followed?
My lord, it means that proper justice should be done, my lord.
Yes.
Proper justice should be done. If this honorable court,
your defense, your concept of justice, the prosecution, their concept of justice would differ in a criminal case.
But for the court, it should remain the same.
Please, you see, there is no use. This court do not want to.
If there is no use, my lord, I take seat, my lord. If there is no use, if there is no use, I take seat, my lord. If there is no use, I take a seat,
going to these things, if you say the court has a biased scrutiny of the record.
My lord, I am saying
what purpose is
bias, just like said just as this honorable court is interpreting alibi, bias, or I did not say bias. I said the court is more, when looking at the records, looking through the lens of the prosecution. It is not bias. Bias has a very big and I will never say bias, my lord. That court is not biased. Even the trial court, even if it may be against me, it is not biased. I do not use this word, my lord. And I think I did not use it. If I did, I apologize. I do not know.
If this court gets it wrongly, then court will apologize, not you.
My lord, it because
if your projection was such, it seemed to be. But then you see,
the lens,
once you have corrected, the court also will stand correct. You say it is.
I say that it look through the lens of the lens of the prosecution.
That means one-sided scrutiny or not? No.
Yes.
Okay.
It is that on scrutiny of the record, it is discerned that it will not be necessary to deal with the case of other accused persons. As such, this court will restrict to the case of accused Kind Lamare. On close scrutiny of the record, it emerges that this application was filed when the matter was posted for final argument, And this honorable court may kindly note when the case was posted for final argument. This was on the first date it was posted for final argument. After final argument, my defense witness came. After posting for final argument, I was released on bail. And prosecution defense witness came before while I was still in custody.
When it was fixed for final argument?
I'll give the date. I'll give the date sometime in 2016-17.
Yes, Mr. Can you reply to all those things? Are you equipped enough to reply if there is any variation?
As far as the current status is concerned, of course.
No. So far as those other aspects are concerned, when it was, see, if we have to go to all those things, that the date on which final agreement, argument was fixed, and thereafter what happened, or before that what happened, all those things. If it is to be scrutinized by this court, can you give all those things? Like
those
details,
I
the
do not
version
have
of the.
Those details, of course, I do not have with me at the moment.
When can you have it? Tomorrow?
Tomorrow it is from.
No, just we'll finish this.
It is from July, my lord. So it is from July actually. Yeah, if it can be taken up next week. Otherwise, my lord, my first thing is, my lord, this is the second criminal revision which is filed, my lord. My respectful submission, my lord, it would be barred by estoppel. How many times you will approach this honorable court, my lord? Earlier you approached this honorable court saying that
That is okay. You see, we'll come to. We'll come to. Once he finishes, then you come. We'll come to your turn. Will come. But then other aspect, I'm saying, so that if we proceed with the hearing, then we would like to finish it. That is.
I don't have any
there
other
should not be
record,
something like that you suddenly stop after wasting.
Only difficulty, my lord, I do not have any other record other than what is there in the.
Madam, can you have it tomorrow or day after, any day? Just see if he's not done, because he may require some to just verify those.
In fact, I can try to help, because I already have the sets ready. If the registry is allows me to file that affidavit, it can be filed today also, because everything is ready. Only that filing was not permitted.
The entire order sheet of the thing.
Everything relevant, whatever questions arising, it is there. And so I can file it today.
See, it is up to them whether they want to have their own instruction or they will depend on you.
I leave it. I'm just talking about assistance.
My lord, I'll try to contact but it may not be, then tomorrow will not be possible, my lord. Because if I am to contact Joy, my lord, at least I'll require a week's time, my lord.
Yes, madam, next week. We may require 1 week's time.
Can you tell me the date?
Next week, my lord, can it be on the 15th, my lord?
This court will be there, see. It is any day agreed upon by you.
I will just check, my lord. 15 should be all right for me also. I'll just give a confirmation. My lord, a date prior or after?
My lord, the difficulty is 14th. I may be out of station, my lord.
The 18th?
18th is a holiday, my lord.
No, 18th is a holiday.
$19th?
Possible. Or otherwise we will issue notice in the matter. After vacation we will do.
My lord.
Will it do your? No, it will. You have problem.
My lord.
We will issue notice today.
My lord.
And we can have it after vacation.
My lord.
Reopening. Will it be all right?
Yes, but in the meantime the court may not proceed till the next date fixed.
No, then we will have it.
Let us have it on 19th.
Then we will have it on 19th. Okay. Heart. So and so, Mr. Happy Bhattacharya, Learned Counsel, please. He may be allowed some time to obtain necessary instruction in the matter. Accordingly, and this is a matter on 19th. But just you one thing, just you say hard learned counsel for the petitioner, then you say on the request of Mr. Kapivata, learned GA, you are
My lord.
learned GA, this is matter of on 19th. In the meanwhile, he will obtain necessary instruction.
My lord.
My lord, may I also be permitted to file that affidavit? Only the records will be there. It will be convenient for all of us, my lord.
Affidavit to bring this to bring into the records the order passed by the court below.
My lord, they did not accept it, my lord.
No. What do you want to? What do you desire to file?
Desire to file, my lord, the documents, my lord, because the records are not there.
These are all admitted documents, or this will be all disputed documents.
No, my lord, which are already on records, my lord.
If it is a part of trial
Yeah,
court
records,
there will
my
be no
lord.
problem.
It's only for convenience,
If
my
it is
lord.
something like that,
No,
that
nothing,
this
nothing.
document
No,
is
no, no.
disputed, then
No, nothing like that, my lord.
okay.
Nothing like that, my lord.
Okay. The petitioner is
Then
also,
this court will not accept it or will
the
not rely
petitioner is
upon
also
it.
allowed to file an additional affidavit, bring into the records the
Relevant documents, my lord, which are already part of records.
relevant documents which are parts of records before the trial court.
Trial court as well as this Honorable High Court also some that Honorable High Court is already yes trial court.
List accordingly. List.
I'm great.
Or maybe we have said all list. 19th. Okay. It will come up on 19th.
19th. Yes, I'm grateful, my lord.
Item number 2.
Right.
And apologies, my lord.
No, it's all right. Wait, there is nothing.
My lord, this matter,
Yes.
last occasion, Lordship allowed me to withdraw my application to file afresh.
Yes.
I'm unable to take instruction from the parties from Karo Hills.
Achha, you have not filed till now.
Unable to, my lord.
Yes.
So may I pray for the application? In the meantime, I'll take instructions.
My lord.
On the request made by Learned Mr. Sameshu, Learned Senior Counsel, list this matter after vacation.
My lord, I appear for respondent 1 to 30. State response.
Yes, please. Write this so and so, so and so. Your appearance will always come. That is always noted.
My lord, no, my lord, since they are private respondents, other responses. I am
It is
for one-
normally it is recorded.
My lord, yes.
They are very good in recording. They do not miss.
Highly obliged, Lordship.
Highly obliged.
Item number 2.
Yes. No one is there. None appears for the petitioner. Ms. A. Pradhan is present on behalf of the respondent. List is met after vacation.
Your pleasure.